My name is Tara Reck. I'm a workers' compensation attorney and L&I lawyer. I've been representing injured workers in Washington state for almost 20 years. There's a lot of confusion about permanent partial disability, or PPD in short. I created this video to share information with injured workers. I hope the video helps people understand PPD. If you had a work injury or occupational disease in Washington state, you can open a workers' comp claim. When the Department of Labor and Industries administers the claim, then the claim is called an L&I claim. If your employer is self-insured, then we call it a self-insured employer claim. Either way, if your claim was allowed, you'll probably hear the term PPD during your claim. PPD stands for Permanent Partial Disability. The Ppd Award is a monetary benefit that injured workers get in Washington state. There are several misconceptions about Ppd Awards. The first misconception is that PPD is some sort of settlement. It's not. A settlement is when there's an agreement between the worker and L&I to resolve a dispute. But PPD is an award that you get when your claim closes. In fact, you get a Ppd award when two conditions happen. Number 1, if you have permanent conditions from your work injury after your medical treatment ends. Number 2, if you can return to some type of work in the same capacity as before. A second misconception is that getting PPD will impact future employment. Many people think that future employers will know about their disability, and that they won't be able to find work because they are stamped as disabled. That's simply not true. Your Ppd award is confidential and it stays like that under your claim. If you return to a job you can perform, there's no need to disclose your Ppd. Let's take an example. Say you had a torn meniscus in a workplace accident. And let's say you had surgery under the claim to remove some of the torn parts. After that, a doctor rates you with 8% of PPD for the lower extremity. Let's also say you return to a job that doesn't impact your knee condition. Since it doesn't affect your job, you don't have to disclose the torn meniscus, your surgery, or the PPD. Now let's move on and talk about the monetary benefit and compensation. The process to decide how much money you receive involves 2 steps. First, a doctor examines you. As part of the exam, they write their opinion regarding the appropriate Ppd. The exam and the report are called Ppd rating. Then, we take the rating and plug it in the Ppd award schedule on the L&I website. Together with the date of injury, you can now calculate your Ppd award. For example, let's assume your work injury happened in 2010. And say the doctor rated you at 15% Ppd impairment of the leg below the knee joint. Then, the award value would be 15% of $86,482.14, which is $12,972.32. It's important to note that the monetary value cannot be negotiated. However, you can argue that the rating was incorrect because it's a medical opinion. In many cases, one medical examiner gives one rating. Then, the attending physician can disagree and give a different rating. If you get a low percentage rating, don't be discouraged. It's not necessarily accurate. You can always get a second opinion from a doctor that has experience in Ppd rating. But if you still think that your Ppd rating is unfair or that your medical exam was biased, it's always a good idea to reach out to an experienced workers' compensation attorney. If you ever need our help, please don't hesitate to call our office for a free consultation.